The urban debate on Magicbricks Now. I'm Faye D'Souza. Thank you for tuning in. There is a battle brewing over water between Karnataka and Tamil Nadu. We'll find out if the state of Karnataka is headed for a crisis. Well, staying with our continued focus on the Cauvery water dispute, and there's a reason why we're focusing on this dispute. What's at stake? Drinking water for the entire city of Bangalore right through the summer next year. Now, the Karnataka government decided to defy the Supreme Court order and pass a unanimous resolution not to release water to Tamil Nadu. The government says the water will not be used for any purpose apart from providing basic concerns of the citizens living in Bangalore for drinking and the Cauvery basin. Pooja Prasanna has this report.
The Karnataka Legislative Council and the Assembly unanimously passed a resolution in what was a carefully worded draft saying that the state in all four of its reservoirs currently has only 26.7 TMC of water, and that water shall be drawn only to fulfill the needs of drinking water purposes of people in the Cauvery basin and also in the city of Bangalore. Although the resolution stays completely clear of mentioning anything about the Supreme Court order, in effect, it would mean that the Karnataka state will not be now releasing 6,000 cusecs of Cauvery water to Tamil Nadu as per the Supreme Court directive. And although leaders from across party lines here in Karnataka say that this will not amount to contempt of court, as the state is not unwilling but is unable to abide by the Supreme Court order, many legal experts still have differing opinions on whether or not this would mean contempt of court. But irrespective of which way it swings, this historic move eventually will bring forth a constitutional crisis where again the question of who is greater in a situation like this, the judiciary or the legislative arm of the constitution, has been brought forth yet again.
Well, on the urban debate tonight, we're asking the simple question: by defying the Supreme Court order, is the state of Karnataka headed towards a crisis? What does this mean then for the citizens of Bangalore? Join us with your opinion. Hashtag Cauvery Dispute on Twitter, or pick up the phone and call us. We have a power-packed lineup to answer this question. Dr. Nasir Hussain, spokesperson of AICC representing the Karnataka government; Sridhar Pavishetty, CEO of the Namma Bengaluru Foundation; M. Harish is a senior advocate and a BPAC member; Anil Chelaguri is a media panelist for the BJP in Karnataka. Suman C. Raman is a sports and political commentator who's been studying this topic very closely. Sanjay Pinto, lawyer and columnist, joining us from Chennai. I beg your pardon. Kailash Vasudev is a senior advocate in Delhi. I want to start with Nasir Hussain. Nasir Hussain, give us clearly right now an update of the Karnataka government's stand on the Cauvery dispute. What are the decisions that have been taken, and what is the plan going forward from the Karnataka government?
I think it's very clear by now to all the people in the state and also in the country that Karnataka government, Karnataka legislature have taken a stand not to share water to Tamil Nadu, because the Supreme Court judgment had mentioned that the priority for water should be only for drinking purpose, then for irrigation, and then for power sector. So going by those orders itself, we had a detailed discussion in the legislature today, which was a special legislative only, as a special session only to discuss about this Cauvery water crisis and the controversy over this water between the two states. I think there was unanimity, and almost all political parties, all elected MLAs, everyone were of the opinion that first the water should be used for drinking purpose for Bengaluru city and also in the Cauvery basin in Karnataka. Only then something else can be thought of. I think as if now this is the decision of the legislature and the government of Karnataka.
Kailash Vasudev, when you hear this response right now, does this amount to contempt of court of the Supreme Court order? What will be the way forward then if and we understand Tamil Nadu has approached the Supreme Court again? Okay, I've lost that connection. I'm going to go to Sanjay Pinto. Sanjay Pinto, go ahead.
Yes.
Same question.
When the gentleman talks about coming together there in Karnataka, he probably means ganging up against the Supreme Court. what we are likely to witness now, in fact, this is entirely precipitated by that resolution, is a constitutional showdown between two estates of democracy in our country, between the judiciary and the legislature. Please understand that when it comes to the Constitution is supreme, and a basic structure of the Constitution is separation of powers between the executive, between the legislature and the judiciary. By actually coming up with this resolution, well, it is a constitutional crisis, as you rightly said, but then these are things that are subject to judicial review. It is contempt of court. Of course, the Chief Minister will say he's caught between a rock and a hard place, between privilege of the Assembly and contempt of court of the Supreme Court. But this is not some Cup Panchayat. This is not some, kangaroo court out there. This is the highest constitutional court of the country. And what the Supreme Court lays down is law that is binding on everyone. To have actually forced this constitutional crisis is extremely unbecoming of an elected government. They are supposed to go by the rule of law. It is very, very, very unfortunate that they should have actually done this and precipitated a constitutional crisis here. I have a feeling that the Supreme Court will step in and put the Karnataka government in its place and make sure that they abide by the order. If they had a problem, they should have filed a review petition. Why force a constitutional crisis?
But the point here that Nasir Hussain was making is that the Supreme Court order specifies that the water needs to be used for drinking. Now, the Karnataka government claims that that is the specification that is being followed in this particular case, that it is not an outright defiance of the order.
No, it is an outright. I mean, you may play with semantics. I mean, I've been hearing this argument for a long time advanced by Karnataka, with all due respect. We all have friends, we all have relatives across the border in Karnataka. But let me tell you, it's juggling with semantics here. If you're saying it is irrigation versus drinking, then it should be irrigation versus domestic supply. If you want to stay with the terminology of drinking, then it's drinking water versus food. Drinking water versus food. That is the way you can actually frame. The narrative is becoming conveniently skewed when it comes to Karnataka, actually framing the debate. If you want to say drinking water is drinking water versus food.
Kailash Vasudev is now connected. Kailash Vasudev, good evening. Thank you for joining us. I want to understand from your reading and the arguments that you're hearing at this point, do you believe that Karnataka's Legislative Council decision not to release water to Tamil Nadu is in contempt of Supreme Court?
See, it's like this. An order of the Supreme Court passed on contest is binding on the parties. Under the constitutional scheme, an order of the Supreme Court becomes a decree. If a decree is not followed,
absolutely,
then the Supreme Court has the powers to take actions for the purposes of executing and implementing the order. Now, if you have a dispute on the Supreme Court order, you have remedies within the Supreme Court. You can go up by way of a review or take appropriate action or move an application. Because this, I understand, is at the interim stage. It doesn't seem to be a final order adjudicating on the dispute on the Cauvery waters between Karnataka and Tamil Nadu. This dispute has been going on since 1990. First, the Interstate Water Tribunal came in. There were orders passed. There were proceedings in the Supreme Court which have continued. But now that an order has been passed, it is the obligation of a state, which is a constituent within the Constitution, to follow the orders of the Supreme Court, because that order has been passed after hearing parties. Interpreting an order of the Supreme Court by using semantics can lead to difficulties for the state not wanting to implement the order. If the order is to implement 6,000 cusecs of water, first it was 15,000, reduced to 10, then 2 and 3, then 6. So whatever is the order of the Supreme Court has to be followed. Let me give you two examples of the Supreme Court where it has taken steps in the most strange circumstances with a lot of restraint to implement its orders. The classic cases of 1995 Supreme Court, where Kalyan Singh as the Chief Minister gave an undertaking to the Supreme Court on the Babri Masjid issue. He said no constructions will be permitted, gave an undertaking. He didn't carry it out. The Supreme Court, in contempt jurisdiction, which it possesses, took the extreme action of sending a Chief Minister to jail. See, Supreme Court's powers are very wide. It is for a constituent state or a disputing state, to a party to a litigation, to come up, seek a clarification, but it cannot turn around and say it will not implement the order. The division of powers does not accept this. Separation of powers under the Constitution is very specific. You cannot possibly take a decision.
Do you believe that the Supreme Court will take action at this point?
The other limb is wrong if there is an adjudication.
Do you believe that the Supreme Court will take action at this point?
Look, I am no one to comment whether the Supreme Court can take action if invoked. I won't say it will or it won't, because that's a matter of judicial discretion and how the court can do it, because it has always been the endeavor of the Supreme Court to keep the states together. It has not been the purpose of the Supreme Court to take a divisive attitude. When there is a dispute, there is an adjudication. The adjudication done in the Supreme Court on river water disputes has been done very, very nicely and very correctly. Beas, Sutlej Canal, the water disputes in the 3 states. So all these things have been taken care of the Supreme Court, and by and large on correct principles of law within the constitutional framework. So therefore, to say whether the Supreme Court will or will not take action, I think would be wrong on the part of any advocate or any person to preempt a decision of the court.
All right, I want to bring in Sumansi Raman here. Sumansi Raman.
It is for the court to decide in the circumstances as to what action it will.
Right. Okay, Sumansi Raman, is this a crisis between the legislature and the judiciary? What is your reaction to what we're hearing right now? Are we expecting now the central government to intervene and help solve the problem?
I would feel that under the Interstate Water Rivers, the Rivers Act.
Sumansi Raman, go ahead.
Yeah. As far as first of all, until recently, Karnataka took this decision not to release water, we could have argued that the role for the central government is limited. Now it's time for the centre to step in. How is it going to step in? Now, obviously, there will be a contempt petition filed in the Supreme Court against the Karnataka government's decision not to release the water. Second, very clearly, I don't see a great deal of importance as far as this 6,000 cusecs in terms of the quantum of water for 1 week. I see the larger decision of appointing the Cauvery Water Management Board as being the much more significant decision that has come out from the Supreme Court recently on this matter. Now, the centre has been given 4 weeks, 1 week is almost done. So, we have another 3 weeks for the central government to appoint the Cauvery Water Management Board. Now, having appointed, let us assume that the centre goes ahead, because they have very little choice. They have an order from the Supreme Court which asks them to do that. Now, if they do that and the Karnataka government blatantly says we can't obey the Cauvery Water Management Board, whatever it may decide, because in the Cauvery Water Management Board, decisions are supposed to be made on the basis of a majority of what the majority of the members of the Cauvery Water Management Board feel. Now, if Karnataka government, which says that we will not obey the Supreme Court order, can then go and say we will not obey the Cauvery Water Management Board order. What happens then? So, I am worried about that as the larger problem, because I don't believe the key issue is just the 6,000 cusecs over 7 days. That is really not the issue. It is hardly a very significant amount of water. The larger problem is, will a state government that has blatantly defied the orders of the Honorable Supreme Court go ahead and defy the orders of the Cauvery Water Management Board as well? In which case, what happens then? Then Tamil Nadu government goes back into
a graver situation to defy the orders of the Supreme Court rather than the Cauvery Water Management Board at this point.
What
the fact that we're moving past the Supreme Court order that is not being followed.
No, but the Cauvery Water Management Board
I would like to come
is in a way being indirectly formed as a result of the Supreme Court verdict.
In fact,
clearly, it's part of the tribunal. Yeah.
Correct. See, no, what I was trying to say is it's a part of the tribunal. An order has been passed by the tribunal, and under the Water Act, there is a power to the central government to frame schemes to implement it. In this case, all this is a fallout of a decree of the Supreme Court, and confronting the Supreme Court by saying that they will not obey the order is a situation which will lead to a constitutional crisis at some point of time. It has happened before. The Supreme Court has taken very firm action in this, and one apprehends that this kind of a situation is not good in a federal polity like ours. The rivers are not the properties of an individual state, they are national waterways. And if you're going to play with national waterways by treating them to be a personal fiefdom, you will have a very difficult situation to come along in the wider view of the subject. The wider view of the subject is you as a nation, we as a nation, the states as a part of the federal polity have to respect that rivers are a part of the different states, and the ownership of water can be distributed, but it cannot be restricted. See a classic example. In Europe, you have rivers like the Danube, the Rhine, the Seine. They flow through countries. They don't flow through states. Even there is an understanding and how to manage the rivers. There is no fights and disputes over waters. Here in a country like ours, where we have states as a part of India, we are creating situations which are leading to very powerful situations in the matter of disturbances all around. You have a civil disturbance, you have elements which come into play, you have a failure to distribute water, which is a natural resource, and a natural resource coming into the first list to the Constitution, to the 7th schedule.
This is a situation that has been
Specifically providing
mishandled?
that rivers are the property of the centre.
Are you saying this is a situation that has been mishandled and mismanaged?
I would think so. And it is great. And it is not, it is, yes, it is. Because you cannot possibly take a decision contrary to a decree to which you have been a party.
Right. So,
If it was an ordinary civil court, the consequences would have been very serious. Here is a constitutional issue which the Supreme Court will have to handle in a manner which stays within the framework of our constitution and the applicable statutes.
all right. Anil Chalagari, come in here. The fact that this problem has been mishandled and mismanaged by the Karnataka government, that's a suggestion coming in from 3 members of our panel right now. Where do you stand on this?
See, first of all, I'm extremely sorry. I have a lot of disturbance in the voice. The point which I would like to make. I know being a responsible government, elected government, and both opposition parties, JDS and my party, Bharatiya Janata Party, have taken a very tough decision with lots of pain, because we do not have water for ourselves. We understand the judicial issue, but there's a lot of anger among the people, and there is a demand of water, and we do not know how is the rain going to respond in the next quarter as well. So with a lot of pain, we didn't want to do such thing, but all of us have come together together with for a good intention, and looking at the reality, we do not have water for ourselves. So if we actually obey the order of Honorable Supreme Court right now, we are going to face a very big crisis in the coming months.
Sumansi Raman.
How convenient? How
I
convenient
think,
is that?
this whole issue is, no, 1 minute. I think the whole problem is the lack of understanding, and fundamentally, this is a question that the Supreme Court has already considered. Karnataka government has put up its representation before the Supreme Court. The Supreme Court has taken note of the quantum of water that is available, and on the basis of it, they have asked for a very, very small portion of the water to be released. Tamil Nadu is facing a shortfall of more than 65 TMC feet. The entire quantity that has been ordered to be released so far over the last month and a half from the court, from the committee and so on, does not even come to 15 to 16 TMC feet. Tamil Nadu still faces over 75% shortfall. Sorry, I'm sorry.
What prevented them from filing a review petition?
The second
adopt
issue
a confrontationist stance? Why adopt? Why adopt a confrontationist stance? Why didn't you go to the Supreme Court with the review? Why didn't you file a review petition?
The fundamental issue
why
is,
force the hand of the
if
Supreme
we have
Court?
water,
Why
we will
challenge
release
the
it to
Supreme
you.
Court?
Itself
Why
not
commit contempt of the Supreme Court order?
You know,
You took an oath. I mean, all these elected representatives have taken an oath to abide by the Constitution. By challenging the Supreme Court, by defying a Supreme Court order, they are not living up. They are violating the very oath of office that they took.
We have also said very clearly that we would utilize all this water for drinking for Bangalore, Mysore, Hassan and Mandya.
That is not relevant, sir. Sir, I am sorry. That is completely irrelevant. What Karnataka does with its share of the water is completely irrelevant to how much of water it has to give to Tamil Nadu.
They can do seminars in Karnataka. Please, this is a Supreme Court order. You have to fall in line.
Sridhar Papishetty.
No, 1 minute. Let others speak also. Come on. No, 1 minute or 1 second. The point here I'm making is let them reserve all these fancy topics for seminars.
Okay, one at a time.
What is the primary purpose of water and what is the secondary purpose of
You have to follow the
water?
rule of law.
If drinking water is not available for Karnataka, for the citizens of Karnataka in the coming months, what is the purpose of growing the samba crop in Tamil Nadu? Because the right to drinking water is always supreme over the right to irrigation and anything else.
All right. Sridhar, your point is taken. I want to go back to Kailash Vasudev. Mr. Kailash Vasudev, the stand. 1 second. Mr. Kailash Vasudev.
Livelihood of farmers.
Water versus
what has happened
versus irrigation water.
See, we do not have water to drink.
And what is
the Supreme Court order has
Okay, one at a time. Gentlemen, one at a time. One at a time.
Us versus them.
Right, one at a
It's
time.
not a case of us versus them. when there's a dispute under the Interstate Water Disputes Act, when there's a dispute, there's a constitutional scheme of things. You cannot violate this constitutional line of control by this open defiance through a resolution.
Okay, all right, Sanjay
Who
Pinto,
gave them
all
the
right.
authority to do that?
No, this whole theory of we don't have water to
There's a
drink
constitution,
is itself
LOC, there's,
something that
as I
can
said
be
earlier,
questioned.
there's
That is what is
separation
so
of powers.
complex.
It's a basic structure of the constitution.
No, so I want to understand, and I'll go to
one minute.
Kailash Vasudev with this. 1 second, Kailash Vasudev. The Karnataka Chief Minister has repeatedly said we have an acute shortage of drinking water. Our southwest monsoon has ended in September. Tamil Nadu is still expecting a northeast monsoon. Never a crop has failed in Tamil Nadu. We are now desperately only fighting for drinking water. Now, these are technically arguments that should have been made to the Supreme Court before the judgment came out, but the Supreme Court judgment
How much water they wasted to douse the flames of protest in Karnataka? How much water did they waste?
By the state of Karnataka.
There is an answer.
Yes, if the state of Karnataka is not in a position to implement the order, how will it do so?
No, please, there is an answer to this. The Supreme Court orders on the release of water start from the 2nd of September up to the 20th of September. 12,000, 10,000, 2,000, 6,000. These variations and orders have come after hearing all the parties. The representations were made in the court by the state of Karnataka and the state of Tamil Nadu. Tamil Nadu's demand for water, Karnataka's inability to supply what Tamil Nadu wanted. After considering it, the variations have taken place in the quantum of water to be supplied. How can you today turn around and say that we didn't make the submissions before the court? Why the variations in the order?
Absolutely.
See, there's a constitutional scheme which the court has followed. They have distributed the water on the basis of availability and statements made during the course of arguments in court.
Absolutely.
The Supreme Court does not know what amount of water is available and not available.
Bang on.
There is an adjudication which has taken place after hearing parties pointing out the difficulties of their own situations. If the arguments were not made, they would have stuck to 12,000 cusecs. What would happen then? They've reduced it, they've altered it, they've amended it after hearing parties, and I repeat that is a very important facet of this case. You have got an order which has been passed on contest by a court adjudicating issues under the constitutional powers. You cannot today turn around and say we will not here follow that court. In a civil proceeding, you cannot challenge the decree which has been passed. Here today, a Supreme Court order in a fantastic jurisdiction unknown to most constitutions, and today we are coming to a situation of defiling the constitution, if I may use the word. You cannot do this as a constituent state. That's my view.
M. Harish, right. M. Harish, this is a moment of absolute crisis in the city of Bangalore at this point, because there is a Supreme Court order that needs to be followed. If it is followed, there will be no drinking water, which is where things stand right now. From inside of Bangalore, how are people viewing this situation, and how did we get to this point?
Firstly, you should understand that this is going to create a deadlock between the legislature and the judiciary. By passing a resolution in the legislature will in no way improve the position of Karnataka before the Supreme Court. This is going to only shift the position of Karnataka from the frying pan to the fire.
I agree with you.
Okay.
Absolutely.
And if we are not able to implement the order, we should go back before the Supreme Court and address the plea of impossibility of performance because we don't have water to supply. We cannot precipitate the matter at this stage,
but
because it may have an adverse impact on our own case when we go before Supreme Court on 27th.
It's a very good point. Nasir Hussain, it's a very good point. The option of an appeal to the Supreme Court, a review appeal was never made. Why wasn't the review appeal used as an option? Nasir Hussain, why wasn't the review appeal used as an option here? Why are we getting into a confrontational mode with the Supreme Court as a state government?
That's exactly what I asked.
Just one. May I come in here? May I come in here? The review has been the plea that we cannot supply the quantum where the Supreme Court ordered first from 12,000 cusecs. It has been brought down to 6,000. It has been brought down because a review plea was filed by the states that this is all that we can supply. How do you say review has not been made? A review can also be an oral request to the court that, look, your previous decision may be wrong. We can't implement this. Therefore, we seek a modification of your order. That amounts to a review of the order. Technically, a review may be to review the whole judgment. That's a technical portion. But a review can also mean an oral request to the court. Look, it's impossible to implement. If it's impossible to implement, please vary your order, which the court has done after hearing parties. This is where the hurt comes in. How can you possibly turn around and say the Supreme Court order cannot be implemented when you have been heard, your figures have been considered, your situation has been considered? Today making this hullabaloo that we will not implement the Supreme Court order, I think is a very wrong precedent which we are setting down, because there are other states having the same right, the disputes on river water distribution. Punjab, Haryana have it. They are there today between Maharashtra and the other states.
Respond to that.
Tomorrow Odisha is going to wake up with Mahanadi.
Now Andhra and Telangana have it.
Yeah, Nasir Hussain, respond to that. Why is this the stand that the Karnataka government is taking after repeated reviews and after repeated orders from the Supreme Court? Nasir Hussain.
Can't have lawlessness in the country.
I think the Karnataka government, well within its rights, has gone back to the legislature, because the government is elected by the people, but definitely the government first elects the MLAs who represent the people in the assembly, and then
but this is a direct confrontation of the executive and the judiciary in the country. This is a direct confrontation of executive and judiciary. This is the basis of our constitution, Nasir.
Please listen to me.
Go ahead.
No, please listen to me. Is there something wrong in Mr. Siddaramaiah going back to the legislature and discussing the situation that the state of Karnataka is facing vis-a-vis the water scarcity? Is there anything wrong in that? Point number one. Point number two, the Karnataka government has not said that they will not implement the order. They said that according to the order, everywhere it is written that the priority should be given to drinking water. We have only about 27 TMC of water, and only
the order is unimplementable. I'm quoting the Chief Minister.
Cauvery Dispute need about 24. Listen to me. Need about 24 TMC of water till next April, May.
Right.
So where do we have water? So I think they are still trying to find ways and means. They are trying to explore the possibilities where they can still go and convince the Supreme Court. So that is the reason why Mr. Siddaramaiah rushed to Delhi and tried to speak to.
But shouldn't this have been done while the case was still being heard, Nasir Hussain? Okay. Let's take the points you were making. Let's take the points you were making. Point number one: what's wrong?
1 minute.
What's wrong? And Sumant Siraman, I'll give you an option. Sumant, I'll give you an option to answer.
What's wrong?
What is wrong if the Karnataka government gets into a huddle to decide what's best for their people? That's the first question.
No. Can I answer that question? Very simple. They did the same thing in 1991 when this crisis happened. They passed an ordinance. That ordinance was struck down by the Supreme Court, which very clearly ruled that in a matter.
That's right.
No, this is a rule. This is a resolution. That is an ordinance. Those are effectively. This is a matter which concerns something which is extraterritorial, which concerns people and territory outside Karnataka, on which the legislature has got no locus standi to pass such a resolution. I cannot pass a resolution on some matter which affects some other state. It is simply not feasible. Second, they knew very well that such a resolution, basically this is a tactic which will buy time. So now what will happen? This will go to the Supreme Court. But this is not the problem at all. The bigger problem is, what if Karnataka refuses to hand over control of the dams to the Cauvery Water Management Board? What do you do? What does the centre then have a choice to do? Because if they can violate the order of the Supreme Court, look, what is going to happen in 4 weeks' time once the Cauvery Water Management Board is formed by the centre? The board will then take control of the dams. Of course, with the active cooperation of the state government, the release of water. Now what happens, which is what Karnataka has been trying to avoid for all these years. Now that is going to happen. Now if they refuse to allow the Cauvery Water Management Board to take control of the dams, in fact, all the 3 states have to do it. Karnataka, Tamil Nadu and Kerala have to hand over control of the dams to the management board.
Sumant,
if they refuse, what happens?
If they refuse, that would be construed as a breakdown of law and order, and then who knows, Article 356 is there in the Constitution.
Sanjay, we know everything on paper, Sanjay, but it's never been done.
Let's not go so far.
It's unprecedented confrontation between executive and judiciary. Sridhar Pabishetty, representing the citizen of Bangalore. Impossible situation for the citizen, the average citizen to be in right now. I know people in Bangalore who just don't know how this is going to play out.
See, essentially what we have to look back is saying that could this deadlock be avoided in the first place at all? You know, a very important very important thing could have been done much earlier, if a fact-finding mission was sent across all the places, and then we had determined what is the amount of quantum of water available, what are the needs, and then what is the fair allocation. Unfortunately, during the discussion, during the appeal and the arguments in the Supreme Court,
I want to come in here.
This has not been handled.
I'm sorry,
enough
there is a
of looking at
tribunal
what is the
order,
amount of
sir.
water
I want to
available
come in
each
here.
of the dams in
Why
both
should there be
sides
a
of the
share?
You know, this is the worrying trend. Kailash Vasudev, the worrying trend is this constant note that the Supreme Court order did not have enough, was not backed by research, that it was unimplementable,
this is where I want
and
to
it had
come in.
not fully taken a look at the numbers.
In the
Kailash.
No, but what will happen tomorrow
please,
when
please,
the
please.
Supreme
Can
Court
also be a
hears the
directive.
appeal,
When you
hears the-
present pleadings and
resumes
when you
hearing this
present...
thing, it will be
One
important
second.
to see
I want
whether
Kailash
the Supreme
Vasudev
Court
to
will
answer this
begin by
question.
looking at
Kailash
the live and
Vasudev,
let live and then look at the
Sridhar
implementability.
Pavisheri, 1 second. The Chief Minister of Karnataka termed
Yes,
the
see,
order
please understand, this is...
unimplementable.
This is... Yes. No, here is an answer. When you came to the Supreme Court in this dispute, whoever came, Tamil Nadu or Karnataka is of no consequence, both the states were before the court. Both states have given their availability of water and requirement of water. They must have calculated on the basis of availability of resources, whether in dams or free flowing. So all these statistics, figures which they are now referring to are before the court. Otherwise, how did the Supreme Court come to a figure of 12,000,
absolutely.
6,000, 2,000, 3,000 or whatever? Figures are there in the court. The court has considered this based on the available information. Please understand, you are adjudicating. Now you take for example the Interstate Water the Disputes Act. There are powers to the tribunal to go into these issues. The tribunal looks into these matters and passes an order. It is then implemented by way of a scheme by the central government. That's the scheme of the act. In the Supreme Court, the adjudicatory process is they hear the parties, they look into the pleadings, they pass an order under 141, which is then implemented under Article 143, the decree of the court. The decree of the court or the judgment is passed on the basis of facts and figures given to the court in any dispute. Here, in a dispute of this kind, availability of water, resources, quantum of water, rainfall, climatic conditions, all these have been put before the court. Let any state say they have not done it. If they have not done it, then they have committed a big mistake in misleading their own people. You've got to give facts and figures. Today, to ripen up an issue which has been decided on the plea that we don't have this and we don't have that, or there is less water, or there is less rain, or how do we go on up to the next monsoon? These are things which they should have disclosed. If they've chosen not to disclose it, then they have to pay the price for it.
All right, so let me bring in the representatives from Bangalore
Today,
right
to turn
now.
around and say legislatively, we're not going to follow the order of the court.
Is the suggestion that's being made repeatedly that the Supreme Court orders were made without proper research, without the numbers? M. Harish, how is that even possible? Does that mean we were that the state of Karnataka was underrepresented in the Supreme Court? How did we arrive at this point?
The argument put forth by the advocate representing Karnataka government will be on the basis of the inputs given by the advocates who are briefing the senior counsel in the matter. And in this present scenario, on 20th, whatever was passed was after hearing the arguments of Falin Nariman at length. However, if we are aggrieved by the order, we should go back to Supreme Court to address our impossibility of performance issue. This is a resolution passing. There is nothing wrong in passing a resolution. But if the resolution is not going to improve your position in the Supreme Court tomorrow on 27th, then it is as good as having not passed the resolution. Because this is a suicidal act according to me. You should have gone before the court on 27th and say that this is a case where we don't have water to supply. And impossibility of performance is an issue here.
And there was 6,000 cusecs of water that
modify
needed to be,
the order. See, I think
Karnataka, water needed to be transferred every day.
Pennywise found foolish in the present scenario.
No, we couldn't have stopped water flowing into Tamil Nadu if we would have stopped passing this resolution today. It was a unanimous resolution which has happened today.
No, see, M. Harish, what you're saying is right, that the state could have gone before the Supreme Court on the 27th, but the water needed to have been released between the 21st and the 27th. So that water would still need to have been released. I think the decision to not release the water is where we stand at this point. Nasir Hussain, respond to the things that are being said on this panel right now, that the state of Karnataka underrepresented its case to the Supreme Court repeatedly. and has arrived at a point where it has an order it cannot implement. And now you're standing at loggerheads with the judiciary, which is unprecedented for any state in this country.
It's for me.
I think you are missing a point here, and most of us sitting in the panel are missing a point that
Go ahead, Mr. Hussain.
See, I have a larger issue to speak about.
One second, I'll come to you, M. Harish. I just want Nisus Hussain to finish his answer.
All the Supreme Court judge. I think again I'll reiterate my point. We are all missing a point that all the Supreme Court judgments did mention that the priority should be to drinking water, should be for drinking water. And what we are all telling is that, and the resolution today clearly states that water will be released only for drinking purposes, and Tamil Nadu has not asked water for drinking purpose, it has only asked water for its samba crop.
So why didn't you tell the Supreme Court that?
At length, everything was discussed at length, the availability of water, the need of water in this area. We already told the court also, I think, on this.
Yeah, so
I'm sure they will go back. I'm sure they'll go back. I'm sure they'll go back. Then see
but Nasir Hussain, the point that M. Harish is
everything
making,
doesn't end here. I'm sure they'll go back to the court.
This decision taken by the Karnataka government puts you in a very, very bad position when the Karnataka government reappears in front of the court on the 27th. How do you plan to handle that situation? How do the lawyers of the representing the state, how will they go back into court on the 27th in the next hearing and say we never followed your order to begin with?
See, I can't really say what will the lawyers argue there, how will they argue there and all. The point is that the legislature in its wisdom has discussed everything and they have passed a resolution, point number one. Point number two, nobody says that the Karnataka government may not go to the Supreme Court. Karnataka government may as well go back to the Supreme Court and try to convince the Supreme Court about the ground situation. That chance is, that avenue is always open. I think the Karnataka may also take that avenue. Maybe they ask the Prime Minister to intervene.
No,
there are so many others.
I think the
government and the Chief Minister are definitely
Raman.
all the possibilities.
Suman Raman, go ahead.
The game plan is very clear. They will now go back to the Supreme Court on 27th
I have a question here.
We wanted to release water, but we do not have water, adequate water or whatever. But now there is a resolution from our assembly. There will be a breach of privilege if we continue to release water in violation of the resolution passed by our own legislature. This is what they will tell the Supreme Court and try to play off. So, no, there will not be. But then it's for the Supreme Court to go into that matter. The whole purpose of passing this resolution was to do the same thing that they did in 1991.
No, it's not.
Go back to the court and say that there will be a breach of privilege. There will not be.
So I have another very basic question, Kailash Vasudev.
That will buy them some more time.
The words that are being used here is that the legislature in its wisdom has passed this resolution. Are we suggesting here that the legislature's wisdom here overrides the Supreme Court's wisdom and the Supreme Court's order? Where does all of this stand?
See, this is where the question is. No, I go one step further. Supposing we forget the resolution passed by the Assembly for the moment, let's keep that in abeyance. They are turning around and taking the view, we don't have drinking water, we don't have facilities for our people, so therefore we are passing this resolution that the Supreme Court order cannot be implemented. They will eventually go to the Supreme Court and say, look, please vary your order or review it or whatever. Supposing the order of the Supreme Court tomorrow says, all right, don't give 6,000 cusecs, you give 5,500 cusecs. What happens then to the resolution? Number two. A resolution passed by the State Assembly at this point of time, after, as I repeat before what I said, after being heard in the Supreme Court, is definitely not an action in good faith.
Okay.
It is an action where the bona fides of the state resolutions can be questioned. They have been questioned earlier. Ordinance making powers have been challenged. Validation of acts to get rid of Supreme Court judgments have been challenged. They've again been struck down. So there are various legal issues which arise. Let's not go into them at the moment in detail. The fact is, the present decision taken today by the Assembly for the purposes of not supplying or complying with the orders of the court in 6,000 cusecs is not in good faith, because all these issues were considered and the ramifications of which the Supreme Court will consider in its own position.
Sanjay Pinto.
Because, as I said, this is a power which the Supreme Court has under 143. You cannot possibly as a state assembly today turn around and say, we were heard, but we will not follow.
Yeah. Sanjay Pinto, go ahead.
That's really a very eloquent and I think the right statement that's coming from my learned senior in the bar there. And I really see, I mean, this whole concept, this allegation that this was an unimplementable order. Just imagine tomorrow in different cases, if state governments are to take the plea that we cannot follow an order, what will happen in the country? What precedent are we setting really here? I fail to understand. I mean, how can you possibly say that an order of the Supreme Court, when you had a chance there to put forth whatever views you had about the storage, about your requirement and all that, and the Supreme Court, after weighing all these pros and cons, has come up with an order. How can you possibly say that a Supreme Court order is not implementable? Tomorrow there could be, and there are in many states, friction between the governor and the chief minister. Supreme Court steps in, an order is passed. What will happen then if you say, I cannot implement the order? Isn't that a point of almost a breakdown of the constitutional machinery there? The rule of law, all these people, as I said earlier, have taken oath under the constitution. Let them uphold that constitution now. I know it's a difficult thing. I mean, it's not easy. You can't really have a kind of King Solomon here to divide the water, because it is a complex issue. That is why the Cauvery Management Board, consisting of experts, will go into this and try and find a feasible solution. It is not a question of us versus them.
I don't think anybody is underplaying the seriousness of this
issue. That is why with lots of debate, we also have a very serious, not just the government, even the opposition parties have come together to make this resolution passed today. So there is a serious issue. The Honorable Supreme Court has to, as an exception, has to hear us again and make a right decision for us.
So are you suggesting, Anil Chalagari, that the decision that has been made was a wrong decision?
My short point, my short submission is that the solution is legal and not political. That is my submission. The solution is legal and not political.
Exactly, and that solution means the control of the dam
goes
to the Water Management Board.
Actually, three different
and the Water Management Board then decides the quantum of water release.
Everyone has come together.
Absolutely.
Let's ask Nasir Hussain, here's a simple question to the government of Karnataka. If the Water Management Board is set up in the next 3 weeks, will control of the dams be handed over to the Water Management Board? Because now, as we have seen, the government has taken a call not to release water, which is a call the government is in a position to take. Whether legal or not is a separate argument, but physically in a position to take. Once you hand over the dams to the Water Management Board, you will no longer be able to control the release of water. Is that something that that the Karnataka government is prepared to do?
No, that is what they want to avoid.
Yeah, I don't know why.
The whole
exactly, that is what they are desperate to avoid.
The Supreme Court order and the consequential directions for the board.
Right, Nasir Hussain, will the government hand over control to the Water Board?
And the scheme of the Act and the Constitution.
Right.
That is what they want to avoid. That's what my view is.
No, I have another scenario there. Suppose now, for instance...
Sanjay Pinto, I just want the answer to this question. Sanjay Pinto, the answer to this question is crucial. I just want, give me 1 minute of silence. Anil Chalagari.
It would be too early to even respond to that. 4 weeks.
Well, I asked the question to Nasir Hussain. He hasn't given us an answer yet. Nasir Hussain, is the government of Karnataka prepared to hand over control of the dams?
Short term to form, there has to be sub-clauses, there has to be too many details which we have to...
Please allow him to answer. Anil Chalagari, allow Nasir Hussain to answer. Nasir Hussain.
See, let us not get into a situation where we foresee certain things and then discuss hypothetically as to what will happen when the board is formed and when the board is not formed. Point number one. Point number two, I think, in the management board, in the water management board, I think there will be experts who will be having technical knowledge of water resources and all those things. I think management boards have been fairly successful across the country. So I don't know what will happen then. and what kind of judgment will come at that time.
Karnataka will
let us
be-
not
will
get
be
into
prepared to hand over
a
control.
situation. Let us not discuss something which is not there in front of us.
No, it is too early to even discuss.
But it is.
This
The
so
Supreme
See,
Court
let
is
the
already
government
ordered it.
decide. Let the government decide what they want to do.
Supreme
Now,
Court
now
has
this
already ordered
now
the
this
water
situation
management board.
is
something on the
now
cards.
now
Not
this
in front
No,
of
I
us.
don't think.
now the
I don't think it's correct.
now the
I don't think it's
resolution
correct to
is-
say that.
Here is
No,
that
I
the
don't
water
think-
board
I don't
will
think
have
it's correct.
experts that the Supreme
I
Court
don't
did
think
not
it's correct
have.
to say it's a hypothetical situation.
come in?
It is not a hypothetical situation.
not. It has already been ordered.
It is a foreseeable. It is something that is in the offing. It is not a hypothetical situation. What will happen? Suppose a center
all of
under
less than-
Article
less than 4
256 issues a directive to Karnataka to comply. What will
I
happen
think
then?
less than
Under
4
Article
weeks is
256,
also
if they issue a directive.
unfair time. There are a lot of long-term impacts which is going to happen. So I think it would be too early to even respond to that. As of today,
M. Harish,
there is
Sridhar
no
Babishetty, the
water
suggestion
for-
here is again that the water board will
See, I
have
have a
access to
suggestion.
experts that the Supreme Court did not have. M. Harish.
Exactly. See, I'll tell you, in a situation if Karnataka wants to hope for any relief in the next date of hearing, it can be done only through compliance of the existing order and not defiance of the order. Firstly. Secondly, the Supreme Court has got ample power to enforce the implementation of its order through the Cauvery Management Board by asking it to take over the control of the dam and see that the order of the Supreme Court dated 20th of September is implemented in letter and spirit. Where will the government stand? Government is stuck between the devil and the deep sea by passing a resolution of this nature without complying with the court order. You should comply with the court order when you want to go before the court by the next date of hearing to seek any modification of this order on the grounds of impossibility of performance of this particular issue because you don't have water to live for irrigation, but only you need water for drinking purpose. This can be addressed even on the next date of hearing. But you should look at the larger picture on 18th October. This is a temporary arrangement. You should look at the larger picture. You are self-damaging. It's a suicidal act. You should go back to Supreme Court and say otherwise Supreme Court has ample power to take over through the Cauvery Management Board and implement its order both in letter and spirit. I think in whatever the legislature does,
But that again becomes incumbent on the central government doing the needful.
I agree.
No,
that again is okay. Whatever the Supreme Court orders, the central government has to move in and give effect to that order.
Legislative resolution, whether they should use that as the garb of not agreeing to the Supreme Court order is a very questionable practice. I think they could have gone ahead and continued releasing the water as per the Supreme Court order and then also gone ahead with the opinion of the legislator and said this is the practicality of what is the overwhelming voice that we are hearing.
But Sridhar Babishetty, the truth is that the city of Bangalore was completely on edge and there could have been a very strong backlash to any sort of release of water.
When the hearing resumes.
There could have been a strong backlash from the
Karnataka has got
population.
water till June.
See,
they
please
have
understand
made the statement themselves. So it is only a matter up to 27th of September.
All right, Kailash Vasudev.
How can you get relief by defiance of an order and not by compliance?
Kailash Vasudev.
No, please understand. See, the situation which we are now facing is very piquant. In the constitution scheme, the states are a constituent part of the union. The union is the one which holds control over interstate waters and rivers. There is a tribunal which is supposed to adjudicate on disputes. This Cauvery dispute has been going on since 1990s. There have been some interim orders by the tribunal, some orders by the courts. There have been situations where the distribution of water has been considered and extensive orders have been passed. Today the court is trying to put an end to this dispute by coming to some kind of a resolution of water distribution because it is the distribution of water which matters. The control of the river is not so much of relevance in the scheme of the act. If you come to that kind of a situation, then the states as constituents of this great country must realize that they have a responsibility to each other. This confrontation between states on the distribution of water is not in the correct perspective of a national polity or a national union. We must realize that the court's decisions are binding on all. To play around, if I may use a loose word, to fiddle around with an order of the court, not wanting to implement it by a state is a very wrong perspective which the state is taking on itself. It has to
dangerous
respect the orders of the court. It must follow them.
Can I make one point?
Because it has been a party to those proceedings.
Right. Sumant Raman, go ahead.
And therefore,
But we are
Yes.
quite confident
I'll give you another analogy of something that is working well, and one of the reasons why it's working. The power sharing agreement between different states. So for instance, Karnataka gets about 400 megawatts of power from the Naval Lignite Corporation plant in Tamil Nadu. They get another 400 odd megawatt from the Kudakulam nuclear plant now, which is functioning.
Under the new dispensation.
Now, all these come under the central government
and the national grid.
Organizations. Central government employees run these, run NLC and run Kudakulam and so on. So that is why there is no problem. They don't, 2 years ago, you may recall, 3 years ago, we had 8 hours and 9 hours of power cut in Tamil Nadu. And at that point of time, there were movie actors and some fringe elements in Tamil Nadu who went in front of an NLC and they carried out an agitation saying power supply must be cut to Karnataka. It was not cut to Karnataka. So you have to understand, and one of the major reasons that happened was the state government, even if it did have could have hypothetically wanted to explore that possibility, it was not in a position to do so because control of these plants lay with the central government. Eventually, the solution to this is formation of the Water Management Board, take control of the dams. In fact, it is not control of the dams only in Karnataka, but also in Tamil Nadu, also in Kerala. And this Water Management Board will then do the distribution irrespective of affiliations or political reasons, purely on the basis of merit.
All right, Sanjay Pinto, has the situation been mismanaged and mishandled up till now?
That is akin.
Well, we've already said
that
that
is
even, as I said earlier, how much water they wasted, how much water did they waste to actually douse the flames of protest? Initially, the law took its own, they took the law into their own hands there. They staged all those violent protests. The Supreme Court at the next hearing did not take too kindly to that. And let's wait and see what's going to happen next week now.
All right, I have to get closing arguments. Anil Chelagiri, the truth is now that we are. I will come to you, Kailash Vasudev. You'll be my last word on this panel. I just want to quickly get in a few options. Anil Chelagiri.
Right, thank you.
The BJP boycotted one meeting with the government, has decided now to sit down with the state government and actually talk this out and band together. What happens from here onwards? Won't this be even more difficult going forward?
See, from the day one itself, there were two meetings. One was on 27th of August and the second meeting was on 6th. It was all party meeting. BJP attended both the meetings. The third meeting, since there was we didn't agree with the government, so we decided only the all party meeting. We did not go out of today's legislation meeting. So we are with the government, state government, in whatever decision it has taken in terms of water. We are very clear in it. We are with the people of Karnataka when it comes to the decision of water. So we would request Honorable Supreme Court to look at this case.
I have one last question here. I have one last question here for Kailash Vasudev. Kailash Vasudev, I am now quoting former Advocate General B.V. Acharya, who said, I don't know what's going to happen now. The state is heading for a constitutional crisis. I hope the centre acts. Is the centre stepping in the only way to avoid what's going to, the sort of confrontation between legislature and judiciary that we are seeing right now, is that the solution at this point?
There are two solutions to this. A, both states must realize that this is a national river going between two states, controlled states, stays with the central government. B, the central government has to step in at some point of time, even under the states, under the River Disputes Act, for the purposes of framing a scheme. The scheme can be the management board. Third, it is for the Supreme Court now to decide how to implement its orders. It will be done, and it will be done at penance and some cost to somebody, which will be very hurtful in the long run, especially for the political leaders.
All right, unfortunately, we've run out of time on this show, but this is, of course, an issue that we're keeping a very close eye on this channel, because at stake here, drinking water for one city and water for irrigation for an entire state. This is Magicbricks Now. Stay. We come back after this break with news and updates of what's happening in your city. That's on the other side. Don't go anywhere.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/Magicbricks Now. And don't forget to click the like button. You can also follow us on Twitter at Magicbricks Now. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/Magicbricks Now.